In R versus Lawrence and also in R versus Caldwell, it was clarified that recklessness on the part of the doer of an act does presuppose that there is something in the circumstance that would have drawn the attention of an ordinary prudent individual to the possibility that his act was capable of causing the kind of serious harmful consequence that the section which creates the offence was intended to prevent, and that the risk of those harmful consequences occurring was not so slight that an ordinary prudent individual would feel justified in treating them as negligible. It is only when this is so that the doer of the act is acting recklessly. If before doing the act, he either fails to give any thought to the possibility of there being any such risk, or having recognized that there was such risk, he nevertheless goes on to do it. In fact, this is the justification for imposing criminal liability for rash acts. Now, coming to the provision of the Indian Penal Code in relation to negligent homicide. It is section 304A, which deals with causing death by negligence. The wording of the section goes like this. It says, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide will be punished with imprisonment of either description for a term that can extend to 2 years, or with fine, or with both. Now, over here the provision refers to an act of causing death, however by negligence or by rashness, and this death caused under the section is the one which is done so without any intention or knowledge of causing such death. The actus reus required under the provision must indicate the presence of mens rea either in form of negligence or in form of rashness on the part of the accused. The provision applies only to such cases where there is neither intention nor knowledge of causing the death of the victim. Hence, the provision does not apply to a case where there is a clear intention to cause the death, or where there is knowledge that the act can result in death. That is, the provision will not apply to the acts wherein a person voluntarily causes the death of the victim. Now, in Shankar Narayan case, the court indeed makes this clarification that intentionally causing death can never be a case that can fall under section 304A. So is also a case where a person voluntarily causes the death of the victim. Now, how do we determine the requisite mens rea of negligence? In order to determine the liability for negligent death and to apply section 304A, courts usually have applied the principle of reasonableness, almost similar to a case of tort. It is true that a law of negligence is founded on the reasonable conduct or reasonable care under all circumstances of a particular case. Hence, an accused will be liable for negligent death provided it is proved that he has failed to take reasonable care and caution expected to be taken by any reasonable man in a similar situation. However, it is important to note that the degree of negligence that is required under civil law and criminal law are different, though the test sounds to be similar. This principle of reasonableness indeed is also important in the case of criminal negligence, and that is the reason why it is said that the law of negligence is basically based on the reasonable conduct or the reasonable care under all circumstances of a particular case. Now, the 42nd report of the Law Commission of India, which was made available in the year 1971, in fact clarified the same by saying that the negligence mentioned in this section is not of the same type of civil disputes, and in civil cases the court insists upon maximum standard of care, while criminal case requires minimum care. If minimum care is taken, then the criminal courts would acquit the accused. So, the standard of care that the report is referring to is the one that can result in exemption from liability under respective laws. In order to bring a clarity to the law, the Commission in its 1971 report further suggested for an alteration to section 304A by saying that an amendment to the section should be made to the effect that there should be addition of the words so as to indicate a want of due regard for human life. However, this recommendation so far has not found its place in the provision of the Indian Penal Code. Let us now see about the possibility of the application of section 304A. To fasten the liability in criminal law, the degree of negligence has to be higher than that which is required under a normal civil law where damages are claimed. The essential ingredient of mens rea cannot be excluded from consideration when the charge in the criminal court for criminal negligence is made. Further, the courts have repeatedly clarified that every slip or mistake is not capable of coming under this particular provision of criminal law. Thus, every slip or mistake is not culpable under criminal law. What needs is a clear proof of mens rea either in form of rashness or in form of recklessness or in form of negligence. Rash and negligent act becomes punishable under section 304A provided there is proof of rashness or negligence on the part of the accused, and not just that, there should also be a clear link between such rash and negligent act on the part of the accused and the death of the victim. Further, to clarify, courts have repeatedly said that there must be an immediate cause of death, and that immediate cause of death should be the one which gets linked with the rash or the negligent conduct of the accused. Hence, the death should not be a remote cause of the negligent or the reckless act of the accused. That being one of the most important conditions for the application of section 304A, rather makes the provision very narrower in its application. Hence, 304A would only apply in a case where the death of the victim is shown as the direct result of the rash or the negligent act on the conduct of the accused. The negligent homicide, in order to be punishable under this provision, hence must be proved to be not just direct but also the proximate result of the rash conduct of the accused or the negligent behavior of the accused. Death must be proved to be causa causans and not just causa sine qua non of the conduct of the accused. Similarly, courts further have clarified that a simple error in the judgment of a person need not be considered as negligence. There should be clear proof of mens rea in form of negligence or rashness on the part of the accused. This is more emphasized upon the cases of medical negligence, where courts have repeatedly said that error of decision on the part of the doctor solely shall not be a case that can bring an offence of causing death under this particular provision. Courts hence must consider the facts of each case subjectively and determine the requisite mens rea before applying section 304A. Negligence must be established by the prosecution or the complainant and can never be presumed by the court. Thus, a mere fact that the vehicle was driven fast or was going beyond the speed limit by itself or per se is not enough to result in an offence under this section. What needs to be proved is the guilt along with the proof of mens rea in form of negligence or rashness on the part of the accused and its causal link with the death of the victim. Unless these are proved beyond reasonable doubt, a case of conviction under this provision is not possible. We can see these clarifications also being made in reference to medical negligence cases both in Suresh Gupta case as well as in Jacob Matthew case. The application of section 304A therefore will be suitable or will be applicable only in a case where you prove that there was no intention to cause the death or there was no knowledge that the act would in all probability result in death. Thus, this section will not apply for voluntarily causing death. It is also essential for us to understand that the general grounds of exceptions which is generally available under law of torts will not get extended to a case of crime, that is a case of criminal negligence. The contributory negligence, which in fact is one of the most commonly sought of defense in a law of tort, is not extended to criminal cases. Hence, unlike a case of tort, contributory negligence on the part of the victim cannot be a ground for defense for the accused in a criminal case. As long as the mens rea in the form of rashness or negligence is established by the prosecution, liability under section 304A is possible under IPC. Similarly, the principle of res ipsa loquitur, which means the thing itself speaks for, which generally applies in a case of tort or a civil matter, does not get extended to criminal case. Had this principle been extended, it would have reduced the burden on the part of the prosecution or the complainant. However, courts have repeatedly clarified that this provision is not subject to the application of this principle, or rather the principle of res ipsa loquitur does not get extended to a criminal negligence case. In a criminal negligence case, it is essential to establish again the mens rea in the form of rashness or negligence on the part of the accused, along with the proof of actus reus on the part of the accused. So is also a case under section 304A, not just limiting it to the cases of medical negligence resulting in death. Being a criminal case, the burden of proof is always upon the prosecution, including that of section 304A related cases. Hence, facts indicating negligence per se is not enough for conviction under criminal law, and the principle of res ipsa loquitur is not applicable in a case of 304A. Hence, proof of elements of crime is essential and mandatory under this provision. The primary reason for not applying this principle, as just briefed earlier, is because if the principle is applied, then the very basic principle of criminal justice system of the India will get affected, according to which the entire burden to prove the crime on the part of the accused or the guilt of the accused is upon the prosecution, and that cannot be compromised at any possible case. Now, while in a civil procedure, a mere preponderance of probability is something that is enough to result in finding the guilt of the parties or in imposing liability upon the parties, while that is not the case in a criminal matter. Presumption of guilt is something that always safeguards the interest of the accused, thereby imposing the burden upon the prosecution. In fact, it is these reasons which have made principle of res ipsa loquitur non-applicable for a case of crime, that is section 304A does not get subjected to the application of these provisions. Now, coming to the extent of liability that is imposed for deaths that are caused due to medical negligence. In the case of medical negligence, it is essential to establish that the culpable negligence on the part of the erring medical professional, and also bring the causal link between such medical negligence on the part of the medical professional and the death of the patient. Unless these two are proved, liability cannot be imposed. Further, such link must be immediate and direct consequence of the alleged medical negligence. Though medical negligence amounting to death can be covered under section 304A of Indian Penal Code, yet courts have impliedly applied a different method of determining the professional liability for negligence even for criminal cases. Courts in India have generally narrowed down the scope of application of section 304A for medical negligence cases.